What's your name, sir?
The principal name is Joseph Martinez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time. Do you understand that, sir?
No, ma'am. No, I do not.
No, I don't think that. I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's good. Okay, well, fight it in court.
So,
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's a name of a strawman or a corporation. So that does not apply to me. It says the accused is capitalized according to the law, which I'm new to. Did I give consent to be arrested?
Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
And they arrest me. That's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained.
what's your name, sir?
The principal name is Joseph Martinez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time.
I got a doable power of attorney filed in Wayne County Register of Deeds. The principal name is Joseph Martinez Logan. I'm an agent on behalf of the principal.
Okay, you're Joseph Montez Logan
Yes,
or Logan?
Yeah, that's my principal. Yes, ma'am.
That's your name. Sir, I'm Magistrate Chartea. You're here on a criminal matter. 250-453-2601. You have an attorney. Go ahead, counsel. Counsel Reagan, you wait for a reading. Stand mute.
Judge, he's representing himself. He's the principal, the agent of the principal attorney of himself. He's representing himself.
Okay. So, Mr. Logan, you want to waive the formal reading, or do you want me to read the charges?
I would like to see the discovery first and the nature of the cause.
Okay, the discovery, that comes after, sir. Okay, this is only an arraignment. So my question is do you want me to read the charges to you or not?
Yes, ma'am. I'd like to hear the reading.
Okay, so, sir, people of the state of Michigan versus Joseph Montez Logan, allegedly on May 15, 2025, in the area of 18637 Albion Street, City of Detroit, did commit count 1, domestic violence, did make an assault or assault and battery upon a Tanisha Logan, a resident or former resident of his or her household, and or an individual with whom he has a child in common, and or his spouse, contrary to the MCL 750.812. Okay, maximum penalty is up to 93 days jail and or $500 fine. Do you understand that, sir?
No, ma'am. I do not understand that.
You do not?
At the moment,
what is it that you do not understand?
Well, because MCL 12.280 gives you the personal liability of my agent capacity, and that gives you understanding of 1 and 2, saying that I have the same rights as a self-appointed a state appointee, the same rights as a state appointee, and I have no interest in this matter.
Okay, well, sir, you are the individual. I'm going to enter a plea of not guilty. It alleges that you did make an assault and battery on a Tanisha Logan. Okay. Again, the penalty is up to 93 days jail and or $500 fine. I'm going to enter a plea of not guilty. Let me give you your court date, sir, which is going to be May 28, 2025, free trial. It's an in-person hearing. Let me make sure. 8:30. In person here at 36th District Court in front of Judge Austin Garrett. Do you understand that, sir?
No, ma'am. No, I do not.
No, I don't think that. I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter, Mr. Logan. But everything is placed on the record because everything is being recorded, sir. But I do believe you understand English. I'm giving you that court date. I'm also letting you know, sir, in terms of whether or not you wish to go forward, however it is, that's going to go in front of Judge Austin Garrett. Do you understand that?
No, ma'am. I do not understand any of the matter, any of the charges, none of what you're saying, because I'm actually the agent on behalf of the principal.
Okay,
No
well,
personal liability in this case, and you try to build a case on me personally, and I'm not liable. I don't have an interest in this matter.
okay. Thank you, Mr. Logan, but you placed that on the record. I've heard that. Sir, you still have that court date. I gave it to you. Okay, if you do not show up, a warrant will go out for your arrest. As to whether or not, like I said, when you want to argue as to motions or not, that's going to be between you and Judge Garrett. Okay, let me give you some bond conditions, sir. That means you need to abide. You're not to have contact with a Tanisha Logan. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the no, that's your residence. So I'm not putting that on. Just no contact and no firearms. You understand that?
What happens with the minor children involved?
The minor children, that, let me see. As to the minor children, sir, okay, that's up to family court. So I'm not dealing with the minor children.
So there's no stipulations?
Those two conditions, okay? I don't see anything to indicate that these children are subject of this case. So do you understand what I've just said, everything so far?
Ma'am, I do not understand, but I will take your ruling on behalf of the principal. I can only do what I can.
Okay, no problem. Okay, this allegedly happened at your residence, sir. I also see in this particular matter, there was no injuries. The complaint declined medical attention. Let me see what else.
I got a question, ma'am. Is she moving forward with the case?
Hold on.
Okay.
There was a 2016 domestic violence misdemeanor. I don't have anything else. What's your question, sir?
Is Tanisha Logan moving forward with the case?
Is she a what?
She's pressing charges, Tanisha Logan.
Okay. So you understand, Mr. Logan, okay? It is not up to the complainant to press charges. Charges come from the county, the prosecutor's office.
Oh, okay. Well, I'm just of the understanding that the state of Michigan is a legal fiction. It's not a living person.
Okay, it's the state of Michigan. That's why I read the state of Michigan, or the people of the state of Michigan versus you, sir. So
Okay.
It is up to the prosecutor's office that files the charges. They have filed the charges. Whatever happens after that, that's going to occur in front of Judge Austin Garrett, his courtroom. So I see that you have local ties. Anything else you want to add, sir?
No, not at the moment. No,
Okay, well, this is gonna be it, sir. In this case, bond is gonna be $25,000 personal bond. Nobody has to pay any money for you to get out of jail. I will caution you, sir, that you have no contact with the complainant. Even if the complainant wants to talk to you, you cannot, because you're under court order. Now, you can take all those issues up with Judge Austin Garrett on your court date of May 28th. Do you understand that, sir?
I was up to understand that this was a misdemeanor charge and not a criminal charge. So I don't understand how.
No, it is a criminal charge. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's crazy. Okay, well, I'll just fight it in court.
So $25,000 personal bond. Good luck, sir. You can step aside.
Judge, I lost Ms. Little. I don't know why she left the breakout room, but I'm in need of a client at the moment.
Okay. What about loan? Did the officers show up for loan?
Yeah, none of these work.
If the officers showed up, we can get Mr. Lowe. Oh no, Lowe It's not an officer case. What happened to, oh, he had to leave. Okay. Get you started on logins. Joseph Loggins. You there, sir?
Yes, I'm here, sir.
Good morning to you.
Good morning.
It's just log in. It's not logins, is it?
Yeah, no S.
City of Detroit versus Joseph Loggins. Case number SP 1322877, counts 1 and counts 2. SP 1688005, counts 1, 2, and 3. SP 1688081, counts 1, 2, and 3. Appearance for the record, please. Ms. Murphy.
Oh, none of these work.
Ms. Murphy.
You're muted, Ms. Murphy. You have to unmute, Ms. Murphy.
Could you hand me that file over there? Print it out already.
All right, what's going on?
Your Honor, as to Mr. Gildersleeve.
Hold on, give me a second. Ms. Murphy, can
Yes,
you
Judge.
put your record for logins, please?
Kathy Murphy, P51422 for defendant Loggins, who appears via Zoom, as do I, sir. Please state your name for the record, or ma'am.
Joseph, sir.
Sure.
All right, I'm gonna put you in a breakout room, Mr. Loggins, with Attorney Murphy. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Let us know what you want to do when you come out. Join the room, please. See anything here that's affecting him from getting a valid license if he doesn't already have one? It's past the matter. We need Loggins on an appointment. Let's go back on the record with Mr. Joseph Loggins. Mr. Loggins, I've given you an opportunity to speak to counsel. Counsel, your client wants an appointed attorney?
Yes, Judge, he would like to proceed to trial, and I'm asking the court to have an attorney appointed to assist him.
Here on this here this is sort of like, I mean, we can appoint one, but this is sort of like everyday stuff that we deal with every single day. It's only really documents. Go ahead.
So pardon me for interrupting, Judge. Mr. Loggins has some sovereign citizen type claims to make in connection with these tickets.
Take your hat off. So if he got the sovereign citizens claims, then he doesn't want a lawyer anyway. Take your hat off, Mr. Loggins.
He did say that he would like standby counsel. Mr. Loggins has some unique claims to make, Judge, that I cannot adequately represent for him at this moment.
And
but
I'm
they
sure
sounded like sovereign citizen claims to me.
And I'm sure probably no lawyer in the country can make that. I mean, he may be able to find himself a lawyer in the country that may try to make that claim. But Mr. Loggins, what do you want to do? I'm going to set a jury trial for this sovereign citizen stuff. Is that what you're?
It's not sovereign citizen stuff, sir. It was due to the vehicle being registered to a living trust at the time of the stop. So I was just informing the attorney that the claim is basically due to a trust being stopped. My vehicle was registered to a living trust.
Okay, thanks.
So the trust being the owner of the vehicle, so I just wanted to move forward as the trustee of the trust, if you will allow it.
Man, that's some double talk there, isn't it?
Judge,
Could I,
Yeah.
could I maybe jump into, I think I get what Mr. Logan say. If I could go into a breakout room with him for a second, I can talk to him. I'm still waiting for my client anyway, so I got some time.
All right, here we go. I told you there's a lawyer in the country that might want to represent you.
Thank you,
Dupree.
Attorney Dupree.
All right, I'll put you in a breakout room. All right, let's pass the matter. Let's go back on the record.
At this point, the case quietly shifts direction. The court is no longer debating unusual legal theories. It is moving toward a structured trial process. Once procedures become the focus, success depends less on personal beliefs and more on presenting evidence and legal arguments that fit the court's established rules.
Logan, you want a trial date, right?
Yes, trial by jury.
Yeah, I think this would be best in trial by jury. Let the jury of his peers determine if they feel. Can I get a jury trial date, please? Are you going to be sitting with him on this, Mr. Dupree?
Judge, he is. He does want to represent himself, but he is asking for standby counsel. I'd be happy to serve in that role. I am on the Third Circuit standby counsel list, if the court would be willing to assign me.
I'll assign you.
Thank you, Judge.
They do jury trials on certain days.
They have a list. They have a list.
Third Circuit does, Judge. At 36, it's all the same list. There's just one list.
No, you're saying, no, I'm saying the list for the jury trials. Let's see if I can find the dates on the list of jury trials. It is a list. Let's see here. We're going to set up 2 dates. Jury trial. Let's see here. And I got the dates. You can just look at it and see which ones. Group 2 for me. June the 10th. It's probably too soon. June 24th. See what we got on June 24th. Or should we just go ahead? Because we've done a kind of calendar. July 8th. What about July 8th?
I was actually going to say, Judge, I have June the 24th. I'm currently booked for a jury trial in front of you. If the court doesn't mind double booking it, and I will, of course, note that Third Circuit frequently double books trials, I wouldn't mind double booking that either, and we can see which one, if either ends out going.
Jury trial, June 24th. Okay.
Very good, Judge.
And then what's the final pretrial on that other case?
I knew you were going to ask that question, but still couldn't find the information fast enough. Give me 1 second, Judge. Judge, the final pretrial is the June the 23rd. You said it the day before.
June 23rd. June 23rd. Your next court date is June 23rd. Let Miss Snyder know that we want all the parties to appear on June 23rd. And not necessarily in person, but we want to make sure that they're gonna bring all the parties, so we don't order a jury if not. And that's going to be the same for your other June 23rd case as well.
I will let her know on both cases. And with Mr. Logan's permission, I'm also going to reach out to Ms. Snyder to request discovery in this matter.
Mr. Logan, do you give him permission to get the discovery for this matter?
Yes.
All right. Final pretrial, June 23rd, 2025. You know that the trial date is going to be in person. It's not going to be on Zoom. But the day before that, the June 23rd date can be on Zoom, 8:30. If you have any motions, I don't know if you're going to have any motions or not.
Yes, I'm gonna have some motions, sir.
Okay, so a motion date. You're going to have to get those in pretty quick.
That's what I wanted to see if you can extend the time so we can get discovery and look at it and analyze it.
I don't know how much analyzing you're going to need on driving license suspended, no insurance, and an unregistered untitled. I don't know what you would what's really, it's not that in depth. I'm gonna give you, Mr. Dupree, he's probably gonna reach out to them today on that. I'm gonna give you until June the 13th on a response on the motion. Motions due June 13th. And the responses will be due June the 20th, okay? If there's nothing further, Mr. Logan, I wish you the best of luck. Have a very good rest of your day, okay?
Okay, sir, can you repeat that again? You say the motions are due June 13th and the responses are due
June 13th. And the response is going to be due June 20th, and I'll make a decision on the motions on the final pretrial date.
Okay, thank you.
All right, best of luck to you, sir. Have a very good rest of your day.
You too. Bye.
Beck, if you could help me out on, is it Kapuma Wimbishi? I'm sorry, sir, if I didn't get it right. It's number one. Miss Jackson, it says 22 CP 214772, 194 days without indictment, no bond as of December the 17th, aggravated battery, willful obstruction, felony. And it says on here, Miss Beck, it was pending an ex parte, and I'm assuming you got the results back.
Yes.
Wow.
The defendant has 3 cycles. The last arrest was May the 9th, 2021 in Dunwoody, Georgia, for terroristic threats, act, and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition.
All right, go ahead, Ms. Beck.
I couldn't get myself off mute. I apologize, Your Honor.
That's okay.
Mr. Kapuma is 45 years old. He has 3 children, all of whom live here in Georgia. He also has a lot of family members, including 2 brothers who live here in Georgia that I've spoken with extensively since he has been at Rice Street. He was employed at ProMove. It was an apartment locator, and he had worked there for over 1 year. He's lived in Georgia the last 22 years. The address on file is still a good address for him. He lives there with his brother, whom I have spoken with. We are asking for a bond not to exceed $10,000, Your Honor.
All right, go ahead, Ms. Patton.
Yes, Your Honor. The state has made contact with the victim in this case. The victim stated that he didn't think the defendant should get a bond, but we're over the 90 days, so we understand that he is entitled to a bond since it's been over 90 without indictment. Victim also stated he and the defendant were co-workers, so there is a concern about his safety, also stating that he still has pain in his jaw. For those reasons, the state, for the aggravated battery charge, will be asking for a $50,000 bond. For the willful obstruction of law enforcement officers by use of threats or violence, which is a felony, state will be asking for $10,000. We also would ask that an ankle monitor be attached to this defendant with a 24-hour curfew, with the exceptions of legal and medical. No contact with the victim in this case, Mr. Keith Johnson, and a stay away from the incident location. Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 1777 Peachtree Street Northeast in Atlanta, Georgia. No further contact with Keith Johnson. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, basic life necessities. Ms. Becker, are you asking for employment? Oh, you're on
Shoot,
mute.
I was muted. I'm sorry. I do believe that he will be able to get a different job if the court has an objection to him working in the same location.
All right. As long as it's not that 1777 Peachtree. So for employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working. 20,000 on count 1, 10,000 on count 2. Best of luck to you, sir. You can leave the booth.
Kapuma.
No, your last name.
I am Kapuma.
Okay, what's your last name? Wimbishi?
Kapuma is my last name.
Okay, so what's the first one then?
Mwembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they
So-
have it reversed? Okay.
So it's Wimbishi Kapuma.
So your name was, like, your last name is Kapuma then?
My last name is Kapuma.
Okay, we'll make sure didn't want to destroy it, too bad with my accent. So I
Okay.
guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily, that's just a typo, but.
yeah, but according to this,
We're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got 285 days without indictment. He had a Feretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear affirm testimony about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary hearing, okay? It's just to establish that there's probable cause. So the DA is going to ask some questions, and then you get to ask follow-up questions, okay? All right? So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department, and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the 4th floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the 4th floor. We go to the right where the clubhouse was, and we found a white male victim named Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious.
Okay.
During that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
You regained consciousness?
yes, ma'am.
Okay, now you said that this happened at what address?
Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that that Mr. Kapuma rendered this man, Mr. unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I was talking
Okay,
about.
all right.
What happened with that?
So during the incident while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs, as well as go ahead and check his vitals, because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr.?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence, or just resistance? There
was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And he said that Mr. Johnson was concerned about how Mr. Capuma was acting.
Yes. So
can you describe how he was acting and what you were told?
Yes. So what I was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had put, according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. Mm-hmm. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
Altercation happened?
Mm-hmm. Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges? Pertinent to this case?
That's pertinent to this case, no.
Okay. So I have for right now, it's your witness, Mr. Capuma.
Mr. Capuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your.
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by, Mr. Capuma. What is your question?
So
who, what, where, why, when?
So in that situation, who was the aggressor in that situation? Because he put his hands first on me.
Just ask a question.
Mm-hmm.
So, okay. So based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
So is there a written signed statement from the witness about that incident to describe what you're saying, so that they sworn like a sworn,
hold on.
A sworn affidavit?
Who, what, where, why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay. Next question.
So there's body camera for the entire event from all 5 officers of what happened?
Yes. So my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So this, I understand. So when will I be able to see the body come? Because I haven't had a chance to look at it, see what exactly happened on that event.
Well, all of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
that's actually,
he's been testifying, and so we object to testifying.
so did you give consent to be arrested?
Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Next question.
Because based on my understanding.
No. Next question. If you want to say something later, you can, but what's your next question for him?
Okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
You said stand up.
No, I told him to stand by. I didn't know if you had an objection.
Yes, I have a judge. I understand when you're giving him leeway, and I understand the reason for that. However, counsel has been not asking direct questions on cross, and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
yes.
What's your next question? What's your next question for him?
Because for me, it's mainly about consent and jurisdiction.
Okay, hold on.
Mm-hmm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right.
Okay.
Anything else with the officer?
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this. That was my mistake. I meant to say the correct, but the correct victim's name is Johnson. Is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Mm-hmm. Yes, ma'am.
Okay, and that's all I have.
Thank you, ma'am.
All right. Any follow up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have a
Stay
good
safe as
day.
well.
All right. Go ahead with the argument. Let's hear from the state.
So, Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Johnson's brain useless by, rendering him unconscious for a period of time, where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the wolf obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges, as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's the name of a strawman or a corporation. So that does not apply to me. It says the accused is capitalized. That's a corporation, and a strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case, because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the God fringe on the flag and the eagle at the top, which shows this is the maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights from my understanding of the law and my rights, my unalienable rights. If I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitution or unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now, bond. Let's see. All right, now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for terroristic threats act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Johnson. He was rendered unconscious. The punch that, counsel was trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that a $30,000 bond is sufficient.
All right, so it'll be no further contact with Johnson. Stay away from Peachtree Street Northeast. You're gonna have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still gonna live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count one and count two is reduced to a misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
Although these hearings involve different charges and different defendants, they reveal the same legal reality. A courtroom is designed to answer specific legal questions using evidence, statutes, and established procedures. When someone argues outside that framework, the court does not automatically stop to debate every personal interpretation of the law. Instead, it continues evaluating whether the required legal standards have been met. Both defendants tried to redirect attention toward issues they believed were more important than the charges themselves. One focused on consent, jurisdiction, common law, and the idea that government authority depended on personal agreement. The other attempted to separate himself from legal responsibility by describing himself as acting for another legal identity or trust. In each hearing, however, the judges consistently returned the discussion to the legal questions that actually controlled the proceedings. That illustrates an important difference between believing an argument is valid and presenting an argument that a court is legally required to accept. Courts operate within procedural rules that determine what evidence is relevant, when objections may be raised, and which legal theories can affect the outcome. Arguments that never connect to those rules usually fail to change the direction of the case, regardless of how strongly they are believed. Another pattern appears in both proceedings. The judges repeatedly gave each defendant opportunities to ask proper questions, make arguments at the correct stage, and understand the next procedural step. Those moments show that courtroom procedure is not only about authority, it is also about maintaining an orderly process where every participant knows which issue is being decided at each stage. Ultimately, these hearings remind us that legal outcomes are often shaped less by confidence than by strategy. Understanding how a court evaluates claims can matter far more than insisting on a position the court has no legal basis to recognize.